You're listening to Systemic Error Podcast. The failure was designed.
Supreme Court ended a midnight election bombshell based on an article by Don Nissenbaum would be. The ballot dating scheme is a point, power, not procedure. The Trump administration is back at the Supreme Court asking for fast ruling that would clear the way for new voting restrictions before the midterms. This immediate fight is framed as a procedural dispute over whether lower courts rule too early. That framing is a cover story. The real story is a March 2026 executive order designed to drag the Postal Service into election gatekeeping by building lists of who may use mail ballots and giving the agency new power to block delivery to anyone not on those lists. Who decided this? The decision maker here is not some abstract federal government drifting toward confusion. It is President Donald Trump using executive power to try to rewrite the conditions of voting by mail. States, non-profits, and Democratic Party committees sued because they understood the obvious. The president does not get to commandeer election administration by order and then pretend the damage is hypothetical until the paperwork is finished. That is the central power structure in this story. One side is trying to impose a new voting regime from the top down. The other side is forced into court just to keep the machinery from being repurposed against voters. Procedure as misdirection. The administration wants the courts to pretend the issue is timing, not intent. Its argument is that because the rules are still being drafted, no one can yet prove harm. That is a standard tactic in modern authoritarian legalism. Break the democratic process into bureaucratic fragments, then claim there is nothing concrete enough to stop until it's too late. The Massachusetts injunction cut through that. So did the practical reality. The article itself lays out fewer than 100 days remain. The Postal Service says it is running out of time in elections. Do not wait for administrative fantasy. This is not a case about whether a finished rule would be lawful. It is a case about whether the courts will let the president spend the calendar as a weapon. The Postal Service is not neutral here. Putting the Postal Service at the center of mail ballot access is a substantive move. The order seeks to make the laws the enforcer of state-related eligibility lists and to empower it to stop ballots from being delivered to people outside those lists. That is not routine administration. It is a deliberate effort to insert a federal choke point between voters and the ballot box. This article's language is careful, but the political meaning is not complicated. When the executive branch tries to hand a postal agency unprecedented authority over who receives a ballot, the purpose is not efficiency, it is control. Courts see the problem and stall anyway. The lower court picture is split, but the split itself matters. One court declined to block the order, another stopped it. The appeals courts upheld both rulings in different ways, which leaves the Massachusetts injunction in place for now and sends the administration back to the Supreme Court. Even the judges who said the challenge was premature still admitted the order raises serious questions about legality. That is a weakness of procedural restraint in a crisis like this. Courts can recognize the danger, then still defer until the damage is fully packaged. That is not neutrality. It is delay with a rubber arm. The larger pattern. This is not just a dispute over mail ballots. It is a familiar authoritarian pattern of using administrative machinery to narrow participation while dressing the move up as legal housekeeping. First comes the executive order. Then comes the claim that no one can object yet. Then comes the scramble to survive the clock. The Democratic coalition is doing what it must do here, litigating, blocking, and forcing the regime's intent into daylight. The deeper lesson is harsher. Democratic institutions do not fail only when they are openly attacked. They also fail when they treat deliberate suppression as a paperwork problem. You've been listening to Systemic Error. Thanks to Alternate for today's article, with the automated voice of Diana. Thanks for listening.